Hello everyone, welcome to Courts Today by Live Law, your go-to source for the latest and fastest legal updates. I'm your host Urvashi Chauhan, here to bring you daily developments, landmark judgments, significant rulings and expert insights from the world of law. Let us begin with the headlines and a concise overview of the top stories. After that, we will delve into full details, providing in-depth coverage and analysis of each update. Union Cabinet has accepted recommendations of the High-Level Committee on Simultaneous Elections, that is One Nation, One Election. The review petitions against the judgment upholding PMLA provisions have been listed in October by the Supreme Court. The top court has sought centre's view on whether charitable trust is a consumer under the Consumer Protection Act of 1986. Regarding the Gyanvapi controversial Remark case, the Varanasi court has rejected a plea to register case against Akhilesh, Yadav, Asaduddin, Owaisi and others. In dealing with the issue of lawyers' strikes, the Supreme Court has sought information on abstention from work by all district bar associations in Uttar Pradesh. The Supreme Court has refused to entertain plea to regulate laser beams and loudspeakers during festivals. The top court has observed that Atomic Energy Act's ban on license to private entities for nuclear energy purposes is not arbitrary. The Supreme Court has held that head of department is guilty if government department fails to comply with the NGT order. The top court has issued notice on a PIL to allow virtual hearing access in Central Information Commission through direct links. In a significant update, the Union Cabinet, chaired by the Prime Minister, has accepted recommendations made by the High-Level Committee on holding simultaneous elections to the Lok Sabha, state legislative assemblies and local bodies. In March, the High-Level Committee had submitted its report on One Nation, One Election. In its report, the committee recommended holding simultaneous elections, citing the burden on government, businesses, workers, courts, political parties, candidates and civil society. To manage the complexities, the committee suggested two steps. Firstly, it recommended holding simultaneous elections for the Lok Sabha and state legislative assemblies. Secondly, it proposed synchronizing the elections for municipalities and panchayats with those of the Lok Sabha and state legislative assemblies, ensuring that the former are conducted within 100 days of the latter. For this, the committee has proposed insertion of Article 82A to the Constitution to synchronize the terms of the Lok Sabha and state assemblies. All the state assemblies which are constituted in general elections held after this article is brought into effect will come to the end along with expiry of the full term of the Lok Sabha. For example, if the article is given effect to in June 2024, then all the state assemblies which are formed after this notification will have a term only till 2029, that is when the term of the present Lok Sabha ends. So, if a state election is held in 2027, the assembly's term will end in 2029 along with the Lok Sabha. To read about this in detail, please visit livelaw.in. In the next update, the Supreme Court has today adjourned hearing of the review petitions pending against the Vijay Madan Lal Chaudhary judgment, which upheld various provisions of the Prevention of Money Laundering Act. The matter was mentioned before a bench of Justices Suryakant, Dipankar Datta and Ujjal Bhuya by Solicitor General Tushar Mehta today, who requested for time, saying that out of 9 review petitions here, the union had copy of only 1. The judgment under review here was delivered in July 2022 and certain provisions of the PMLA relating to Enforcement Directorate's power of arrest, attachment, search and seizure were upheld. Subsequent to this decision, the instant review petitions were filed. The review petitions will now be taken up on 16th and 17th October. Stay tuned with us. Next, the Supreme Court today sought assistance of Union of India through Ministry of Consumer Affairs as a respondent in a case involving the issue whether a charitable trust can be considered a consumer under the Consumer Protection Act of 1986. The definition of consumer under this act includes any person who buys goods or avails services for consideration, excluding those who purchase goods or services for resale or commercial purposes. This issue was referred to the larger bench in 2019 by a division bench which observed that the definition of person under the Act is inclusive and could potentially include charitable trusts also. Today, a bench of Justice Abhay Ok, Justice Pankaj Mittal and Justice Asaduddin Amanullah permitted the amendment of the cause title to include Union of India and posted the case to 16th October. And now let me tell you, a Varanasi court has dismissed a criminal revision plea seeking registration of criminal cases against Samajwadi Party chief Akhilesh Yadav and AIMIM chief Asaduddin Owaisi over their alleged controversial remarks concerning the shivling purportedly found inside the Gyanvapi mosque premises. In his revision plea, the revisionist advocate Harishankar Pandey, who is the complainant, had sought registration of an FIR against Yadav and Owaisi for allegedly inciting religious hatred by making controversial remarks regarding the structure found inside the Gyanvapi mosque premises. It is his case that Akhilesh Yadav, Owaisi, his brother, and many others were making objectionable remarks against the shivling, which resulted in hurting the sentiments of Hindus. However, Additional District and Session Judge Varanasi, Vinod Kumar, rejected the revision plea, finding no case of hate speech. Earlier this month, the Supreme Court bench of Justices Surya Kant and Ujjwal Bhuyan had expressed serious displeasure at the Faizabad District Association, Uttar Pradesh, for allegedly calling strikes and abstaining from judicial work. The concerned lawyers in Faizabad were stated to have abstained from work for 66 days out of a total of 134 working days between November 2023 and April 2024. The court had called on its office bearers to file an affidavit undertaking that they shall never pass any such resolution in future. Taking into account the undertaking filed by the office bearers of the Faizabad Bar Association that they will not pass any resolution for abstention of work, the Supreme Court has now expressed an inclination to expand the scope of the proceedings and has called for data on abstention by all district bar associations across the state of Uttar Pradesh. The matter relates to Faizabad Bar Association approaching the Supreme Court against an order of the Allahabad High Court wherein it had set up an elders committee to manage the Bar Association's affairs and ensure elections were held by December 2024. The court was also informed that some courts in UP did not even have 50% working days in the last 2 years. Further, the bench conveyed dismay at lawyers' abstention from work for the smallest of reasons such as bad weather. The Supreme Court has refused to entertain a petition seeking directions to regulate use of light laser beams and loudspeakers in public spaces, gatherings, and events during festivals. The petition was filed against the Bombay High Court's order which had disposed of the PIL against usage of laser beams and loud sound systems. The High Court refused to pass substantive directions saying that the aggrieved persons can file complaints before the authorities. Challenging the High Court's verdict, the counsel appearing for the petitioner submitted that there was no statute regulating the use of laser beam lights. The bench led by CJI D.Y. Chandrachud and Justices J.B. Pardewala and Manoj Mishra heard the matter. It refused to consider the same, pointing out that the High Court had permitted the petitioner to make a representation before the concerned authorities. In another update, the top court has upheld Atomic Energy Act of 1962, which prevents private companies from getting a license to work with nuclear energy. The court was hearing a petition from an Indian physicist living in USA who wanted a license for his technology that produces clean energy with less radioactive waste. He objected to Section 14 of the Atomic Energy Act, which restricts involvement of private entities in licensing for nuclear power. Its subsection 1A states that no license shall be granted to a person other than a department of the central government or any authority or an institution or a corporation established by the central government or a government company. The bench led by CJI D.Y. Chandrachud observed that the provisions of the Act are not arbitrary and no fundamental rights of the petitioner here were violated. The court said that these provisions serve a salutary public purpose by ensuring that nuclear energy is used only for peaceful purposes under stringent government control. The Supreme Court has observed that if a government department fails to comply with an order of the National Green Tribunal, the head of the department shall be deemed liable for such failure as per the NGT Act. The background here is that in September 2020, the NGT passed an order in an application against Union of India alleging encroachments and illegal activities such as salt harvesting and fishing in the Wildlife Sanctuary in Gujarat's run of Kutch. The NGT directed the concerned authorities to refrain from granting any leases in the sanctuary area without the consent of National Board of Wildlife and the Forest and Environment Department. The tribunal also ordered that no activities be allowed within a 10-kilometer radius of the sanctuary or beyond the parameters prescribed by law for permitted activities. Then in 2023, the appellant filed an execution application alleging that 15 government officers had failed to comply with the NGT's 2020 order and sought action against them. Let me tell you here that Section 26 of the NGT Act provides for penalty such as imprisonment and or fine on individuals or companies that fail to comply with NGT orders. And Section 28 states that if a department fails to comply with NGT orders, the head of the department will be deemed guilty and liable for prosecution. However, the tribunal asked the appellants to remove the names of the 15 officers as they were not personally named in the original case. The appellants were instructed to name the original respondents instead. Displeased with this order, the appellants took the matter to the Supreme Court. A bench of Justices Abhay S. Oak, Asaduddin and Augustine George Massey of the top court set aside this order, deleting 15 government officers. The court observed that after receiving notice, the officers could have raised all permissible defenses, including whether they were responsible for complying with the NGT's 2020 order or not. But at the stage of issuing notice, the tribunal could not have interfered. Thus, the top court has now directed the NGT to issue notice to the 15 government officers and give them the opportunity to present their defense. The court clarified that it has not adjudicated on whether they were responsible for violating the tribunal's order and left the question open for the NGT to decide. And lastly, the Supreme Court has sought response from Union in a PIL seeking directions to Central Information Commission to give access to virtual hearings by issuing direct court links. The CIC is an independent authority established under the Right to Information Act of 2005. It hears appeals and complaints when citizens are denied access to information by public authorities. So if a person is not satisfied with the response of a public authority to their RTI request, they can appeal to the CIC. The petitioner in this case, an advocate, stressed that the CIC has nationwide jurisdiction but has been conducting hybrid hearings through NIC studios instead of providing direct links to online hearings. This causes much inconvenience to appellants who are required to travel to studios to take part in online hearings. The plea also stated that in response to the RTI query regarding any proposal for online hearing, the CIC replied that no such proposal was under consideration. The Supreme Court has now issued a notice in this PIL. The court has issued notice on another PIL by the same petitioner seeking virtual hearings for land acquisition compensation claims by the Land Acquisition and Rehabilitation Authorities. The LARRs were established to provide speedy resolution of disputes related to land acquisition, compensation, rehabilitation, and resettlement. But according to the petitioner, they have led to long delays in case disposal and caused hardships for landowners. For more details on the cases mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Don't forget to like, share and subscribe to our channel. You can also support us by donating through the thanks button at the bottom of our videos or by becoming a member for just 89 rupees per month.